Hi everyone, welcome to another one of our webinar series. So today we're looking at credit and debt issues arising from the end of the mining boom. My name's Carly, I'm from Community Legal Centres Queensland, and just before we start I'll make sure that everyone can hear me. So can you please on the control panel in the top corner, please click on the hand button to show me that you can hear. So if you can just pop your hands up there, I'll know that you can all hear me. Just give it a bit, I've got a couple of hands up, but I'll just give it a bit more time. Oh, there we go. Okay, so thanks everyone. I think you can all hear. If you do have any issues, you can just use the questions box or send me an email and I'll be able to then sort any issues out. So firstly, I would like to acknowledge the traditional owners of the land on which we are holding this webinar today. So in Brisbane, they're the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and in Perth, as well as other areas of Australia, I'd like to also pay my respects to the traditional owners of the land throughout the country. So today we have Gemma and Georgina from the Consumer Credit Legal Service in WA presenting to us, and so they will present on credit and debt issues arising from the end of the mining boom. So we know that communities across regional Australia are being affected by the downturn in mining and resource jobs and the impacts this is having on workers, families, homes and finances. So Gemma and Georgina will discuss repossession of family homes and investment properties, shortfall debts, lenders' mortgage insurance, early release of superannuation, the Financial Ombudsman's approach to mortgage sales, and an update on the law around payday loans. So what we'll do is we are recording today's webinar and that will be up on our website later this afternoon. And we'll also take questions just at the end of the session today. So there are two ways you can ask questions. You can press the button that looks like a hand on the GoToWebinar control panel and we can unmute you and you can ask your question via the microphone, or you can type your question into the question box and we'll read those out to Gemma and Georgina at the end. So without further ado, I might pass over now to Gemma and Georgina to provide their presentation. So thank you very much, guys. Take it away.
Thank you, Carly. Okay, so good morning to everyone in WA and good afternoon to everyone else. So I'm Gemma Mitchell, I'm the Managing Solicitor of the Consumer Credit Legal Service.
And my name's Georgina Malloy and I'm a solicitor at the Consumer Credit Legal Service.
So as Carly says, we're here today to talk about the credit and debt issues arising from the end of the mining boom. This has been a much discussed topic in WA. So there's been many issues coming out of this, including unemployment, cost of living, government expenditure. However, one of the most significant issues in WA at the moment for everyday households has been the value of property, in particular mortgages and negative equity. So just yesterday there was an article in the West Australian newspaper with the headline, "Homes Lost as Mortgage Paying Mounts." And the article went on to say that in the year to 30th of September, Supreme Court records show banks moved to seize 1,226 properties. So it is a really big issue and it's something we see on a telephone advice line quite regularly. Okay, so Consumer Credit Legal Service, or CCLS-WA for short, is a not-for-profit community legal centre based in metropolitan Perth that provides legal advice and assistance to and advocacy on behalf of consumers with issues arising out of their credit and debt-related problems or out of their Australian consumer law disputes. CCLS-WA operates a daily telephone advice line service which consumers use to request legal advice and information. In the last financial year, we provided 2,677 pieces of legal advice. Where a matter is too complex to provide a one-off telephone advice, we will look to open a case file if we've got the resources to do so. We also provide other resources such as fact sheets and sample letters on our website. We deliver community education programs So we've got a monthly radio segment on 2 different community radio stations, and we run financial literacy training to high school children. And finally, we undertake law reform work. So we have 3 solicitors, a managing solicitor, an office manager, a legal administrative assistant, a bookkeeper, and approximately 20 law student or law graduate volunteers. And it's our volunteers who run our telephone advice line. So our volunteers assist us with all of our work, and I want to thank one volunteer in particular, Damon Van Kempen, who's assisted Georgina and me in putting together this presentation. So here, this slide sets out what we're going to talk about today. So first of all, I'm going to go through some recent figures and then talk about repossession of investment properties and the family home. Next, we'll talk about the FOS approach to mortgagee sales, shortfall debts, lender's mortgage insurance, and early release of superannuation. Originally, when we planned to do this webinar, I had included payday lending in the content, as Carly said, but there have been a lot of changes in the payday lending landscape at the moment, and that's really sort of warrants a presentation all on its own. So unfortunately, we did have to cut that out of this presentation. Okay, so on this slide then, we've got a link to a Guardian article, and this was an interview that myself and other consumer advocates from WA did back in May on the issue of the mining boom. Some of the figures quoted in this article, they're quite staggering. The article talks about the drop in property prices in the Pilbara mining towns of Karratha, Port Hedland and Newman. According to more up-to-date information from the Real Estate Institute of WA, in Newman, the median house price fell from $867,500 in 2013 to $150,000 in 2017. And units fell from $575,000 in 2013 to just $80,000 in 2017. And those are drops of 82% and 86% respectively. So this issue isn't just in relation to house prices, it's also in relation to the rental amounts. The article quotes the figure of rental incomes of $1,600 per week dropping to $370. And so this isn't even enough now to cover mortgage repayments. So on this slide, you can see a graphical representation of the drop in house prices in 2 of the mining towns in the Pilbara, Port Hedland and Karratha. So these figures show that since 2013, the median house prices in Port Hedland have dropped by 67%, and in Karratha by 65%. So this is a major factor that's contributing to the prevalence of repossessions and shortfall debts being incurred by our clients. This slide shows a comparison between Perth Metro prices, regional WA, and the rest of the country. So in January of this year, Moody's Investors Service said that Outback WA was the worst performing region in Australia in terms of the equity in mortgages attributable to housing prices. Based on indexed house prices, 43% of mortgages in this region were in negative equity. So this means that for almost half of all the mortgages, more was owed on a house than what it's worth. And then that table goes to show that in the quarter to March 2017, over 20% of houses and 30% of units across Perth were sold for less than the previous purchase price. So this is really hard hitting for Perth, but particularly for rural regions, where the percentages of loss-making sales are much higher in regional WA than the national average. This final set of data that I want to look at is the Equifax data on mortgage applications. Equifax is the credit reporting body that records applications for credit. It used to be called VEDA. You might recognize that name. You can see that this crash in fortune statewide is also reflected by a drop in mortgage applications. Things are still getting worse for WA, and mortgage applications are weakening significantly in strength, particularly compared to the rest of Australia. What this translates to is that if no one is applying for mortgages, then the homes are not being sold. In the September 2017 quarter, mortgage applications fell by 19% from the previous quarter, being the largest decline by any state or territory. So, what does this mean for our clients in WA who've bought investment properties at the height of the mining boom? So I'm going to introduce you to our client Rachael. Rachael first contacted CCLS WA a year ago. Rachael had 4 properties with loans to purchase each property taken out with the Bank of Oz. And the total amount of these loans was $1.6 million. Rachael had a family home in the northern suburbs, an investment property in the northern suburbs, and 2 investment properties in Karratha. One of the investment properties in Karratha had been purchased in the 90s for around $100,000. The other had been bought more recently for over $700,000. Rachael was not working due to illness and injury and was in default on all 4 loans. Her total arrears were over $100,000, including around $35,000 on her home loan. She had made a claim on her income protection insurance, but her claim was refused. She was advised that there was a mistake in the insurance policy that prevented her from making a claim. Rachael had instructed a private solicitor in relation to that issue. Rachael also had other debts and was at risk of having her utilities cut off. She also had other loans and credit that she had maxed out trying to keep on top of the mortgage repayments. The property in the northern suburbs had been tenanted, but the tenants had recently moved out. The properties in Karratha were empty. Rachael received a default notice at about the beginning of last year and put forward several proposals to the Bank of Oz, including an offer to apply to release her superannuation early, but this was rejected by the Bank of Oz. Rachael contacted us sometime after she'd been served with a Supreme Court writ from Bank of Oz. She was unsure whether a default judgment had been entered against her. Rachael wanted to know, could she sell the properties herself, and could she use her superannuation to pay the arrears? Okay, so one of the first things we advised Rachael was in relation to the investment properties in Karratha and the northern suburbs. A very important point to note in Western Australia is that a lender does not have to initiate court proceedings to repossess a secured property. Under Section 108 of the Transfer of Land Act, a lender has the right to repossess and sell a mortgaged property if the borrower is in default, the lender has served the borrower with a default notice or notice to pay, and the borrower has not fixed the default within the time specified in the notice. If the borrower is unable to comply with the notice to pay, the lender is legally entitled to, and this is a quote from the Section 106, from the Act, make and sign such transfers and do such acts and things as shall be necessary for effectuating any such sale. So this includes entering onto the secured premises, changing locks, and removing occupants. However, removing occupants can sometimes require agents to use force, which risks resulting in criminal or civil charges. So the reason that lenders often choose to take court proceedings, even though they're not required to, is so that a sheriff, who is a court official, takes the action to enter the premises. This means that for many residential investment properties that become vacant, upon default and issuing a notice to pay, a lender can immediately take possession of the property and commence the sale process if the borrower doesn't remedy the default in the time stated. So if you do have a client with a vacant investment property, they should be made aware of a lender's rights to take possession of that property without having to go to court. So if we go back to Rachael, what we said she may wish to do was to contact Bank of Oz to find out the status of the investment properties and whether or not she was even still in possession of them. And if so, she could then attempt to negotiate to sell them herself. Alternatively, she had the option of surrendering the properties to the Bank of Oz for them to sell the properties. And I'll just pass over to Georgina now.
So now we'll be discussing voluntary surrender. One option that some clients consider when facing the prospect of home repossession is voluntary surrender of their property. The process for this is that the borrower notifies the lender that they intend to surrender the property and provide vacant possession. The lender then takes over the sale process and the borrower is no longer involved in selling the property, but is of course still liable for the debt they owe to that lender. Voluntary surrender can be fraught with problems because the borrower loses control of the process for selling their property. In some cases, it might be appropriate for certain clients, but it is usually preferable that a client sells their property themselves. Now, I will look at the pros and cons to voluntary surrender. For a few specific clients, there may be advantages to choosing voluntary surrender over another process. The first advantage is avoiding further legal costs and enforcement expenses because the parties are not going to court. This might be useful if there is little equity left in the property and the client is concerned about a large shortfall debt after the sale. Another advantage is avoiding court proceedings if a client was concerned about having a court judgment on their credit file. And the other main advantage to voluntary surrender is if a client is not in a position to manage the sale process themselves. This could be due to ill health or other circumstances, and it means the client doesn't have to manage that process, but the lender would instead take over the management of the sale. There are, however, clear disadvantages for a client voluntarily surrendering their home. The main negative is loss of control. The lender has control over both the sale process and the sale price of the client's home. There is no requirement for a lender to keep the borrower informed about the progress of the sale, and this can be very stressful for clients who want updates about how the sale is going or feel that the lender is not getting the best price they could be for their home. Finally, a client still may have a shortfall debt after voluntary surrender and the sale of the property, and this is particularly relevant in WA at the moment, as Gemma has discussed. So now we'll look at some scenarios about voluntary surrender. First, we'll look at Jim's case. Jim and his wife Ada, an older couple, entered into a loan to purchase their house. They were able to meet the home loan repayments, but around 2 years ago, Jim's wife Ada was diagnosed with a serious illness and given only a few weeks to live. At the time, Jim spoke with an employee at his local bank branch about what would happen if he couldn't make the repayments anymore. Jim asked the bank to buy back the house. The employee at the local branch told Jim to stop making loan repayments and to move out of their home and give the keys to the bank. They were told if they did this, then they would not be bound by the obligations under the loan once they handed back the house keys. And this advice was clearly wrong. Ada and Jim decided to voluntarily surrender the house on the basis of this incorrect advice, and they moved out of their home and posted their house keys to the bank. Soon, Ada passed away, and then Jim suddenly received a notice of default from the lawyers acting for the bank. Jim did not understand why he was in default, was very shocked and upset, as he had thought giving the keys back meant he didn't owe any debt to the bank. He then contacted our office. Here, the bank had failed to correctly record that Jim and Ada had surrendered the property, and they failed to give them correct advice about voluntary surrender and the shortfall debt they would have afterwards. Later, the house was sold by the bank as mortgagee in possession, and there was a shortfall debt. The bank then sought to pursue Jim for this debt owed on the loan after the house was sold, and also land rates and utility bills for the property before it was sold. We assisted Jim to negotiate a settlement with the bank as there had been breaches of the National Consumer Credit Protection Act and also the Code of Banking Practice. Now let's look at another example of how voluntary surrender can go wrong with Kath's case. Kath had defaulted on her investment loan that financed the property in Perth. She had severe anxiety and decided to surrender the property to the bank, as she was not in a position to sell the property herself and manage that process or go through the stress of court. Kath entered into an agreement with the bank to surrender the property, and the bank would sell the house as mortgagee in possession. She gave the keys to the property to the local bank branch some time ago. Since returning the keys, Kath's property stood vacant and the bank was not selling it. It appears they simply forgot about the property, and Kath felt there was little she could do about it. Meanwhile, house prices in Perth were dropping, Kath was getting bills for the utilities and other levies for the house, and was worried about the interest and fees accruing on her loan, not to mention the deteriorating state of the property as it was vacant, which would affect the final sale price. Kath contacted our offices and we assisted her to negotiate with the bank so they would refund to Kath the interest charged on her loan for the time following the voluntary surrender, which amounted to almost a year, and refund the utilities, rates and other amounts owing on the property for the period after Kath had surrendered the property until the dispute was resolved. Now back to Gemma.
Thank you. All right, so if we go back to the Rachael scenario, the next thing we had to advise her on was the repossession process for her family home. The laws around repossession of property have changed quite significantly in the last year. Our office was consulted by the Supreme Court of Western Australia in relation to the proposed amendments. Under the old laws, an application by a mortgagee used to be made under Order 62A of the Rules of the Supreme Court. From November 2016, this order was removed and relevant provisions were inserted into Orders 4AA and 13. Under the new rules, there is now a requirement for a notice setting out the borrower's rights in relation to the writ to also be served with the writ. This notice is called a Form 4. This form is based on a New South Wales notice that we provided to the court. So on this slide here is the text of the Form 4. It's got a very good warning to say that if the borrower doesn't respond, they risk losing ownership of the property. It directs them to the legal aid website and helpline, and it also gives examples of what is not a legal defence, for example, unemployment. And we think it's quite important to note that if the client files a defence, especially if there is no legal defence, this can affect the client's ability to then lodge a dispute with FOS and CIO. So it's quite a good idea that this form actually sets out that you don't just have a legal defence to a claim by simply being something like unemployed. Now, if the client is served with the writ without being served with this notice, then that is grounds to have the service of the writ set aside. And we really think this goes a long way to explain the severity of the proceedings to the borrower. So now I'm going to talk about a client of ours, Sigourney. So in late 2016, Sigourney came to our office for advice. She'd been forced by her ex-husband to sign some documents that had guaranteed a loan for his business. The documents she signed also included a mortgage over her home in favour of the lender, Top Cash. Her ex-husband absconded, leaving the loan to Top Cash unpaid. Top Cash's lawyers were being fairly aggressive. The matter was quite complex, and so we sought to refer her on to a law firm pro bono. We couldn't go to FOS or CIO as the lender wasn't a consumer credit provider. Whilst we were in the process of doing this and attempting to place the matter, Sigourney was served with Supreme Court writ from Top Cash. However, she wasn't served with the Form 4 notice. We contacted the WA Bar Association for some assistance, and we were advised that as the client hadn't been served with the Form 4 notice, then this was grounds to have service of the writ set aside. By way of a conferral, we contacted Top Cash's lawyers and we raised this with them. We provided them with a certain period of time within which to remedy the defect. Otherwise, we would bring an application to set aside service of the writ. A few days later, our client was served with another writ, but this time with an accompanying Form 4 notice. At that point, we had had a response to our request for pro bono assistance, and we were able to refer the matter on. Top Cash's failure to serve the Form 4 on Sigourney provided her with just enough extra time to obtain pro bono court representation. So it's really important to check that if you do have a client who's been served with a writ, that they've also been served with the Form 4, as this is grounds to have the service of the writ set aside, and it can provide your client with some much needed additional time. So if we go back to the new rules, the borrower has 10 days from the date of service of the writ to enter an appearance, and this hasn't changed. Under the old rules, however, if the borrower didn't enter an appearance, the lender could apply for default judgment, which was a procedural step and required both parties to attend the court in chambers. Now, the Supreme Court thought that this step was a source of confusion to a lot of borrowers, because the borrowers thought that this was their chance to present their defence or to have their day in court. They couldn't understand the difference between a trial or an interlocutory hearing in chambers, and we agreed with the Supreme Court's position. The option was therefore for the Supreme Court to get rid of this step and allow for the lender to make an application for default judgment on the papers only if the borrower was in default of appearance. Now, the problem with this is that the borrower defendant would only then have 10 days to respond to the writ, and we found that even if the clients were in default of appearance, if they were served with a Supreme Court writ and hadn't responded to that, we found that sometimes they did then respond to the application for default judgment, and it was that point they would then contact us for advice. So we said to the Supreme Court we considered that this 10 days wasn't long enough for the borrower to seek legal advice and decide what to do, and considered an additional few days, so 21 days in total, would be an appropriate amount of time for the borrower to obtain legal advice and decide what to do. So the Supreme Court made a rule that if the borrower does not enter an appearance, the lender must serve on the borrower a notice in Form 36A, which says they intend to apply to the court for orders of possession of the property after 11 days of service of that Form 36A. So if the borrower still fails to respond after being served with that form, the lender can then apply for a default judgment. So it's even more important than ever that if you do have a client who's served with a writ, that they act quickly. Once a judgment is entered, the remedies that are available to the client are very limited, as they no longer have the option of going to either FOS or CIO to challenge the debt. Another new rule is that once a default judgment is made against a borrower, it must be personally served together with a Form 36C, and this form tells the borrower that they can apply to have the judgment set aside. The judgment will order that the borrower deliver vacant possession of the property to the lender within 28 days, unless the court orders otherwise. If the borrower doesn't vacate the property in that time, then the lender can apply to the court for an enforcement of the judgment, and this usually involves an order that the sheriff of the court attend the property to change the locks.
Now we will talk about mortgagee sales and the obligations on a financial services provider, such as a bank or other lender, at this stage once the property has been repossessed. The sale proceeds from property first go towards paying off the outstanding amount left on the loan, as well as the costs the lender incurred in selling the property and enforcing the repossession, and then any remaining sale proceeds will usually be handed over to the borrower. Sometimes, however, the sale proceeds will not be enough to cover the loan and the lender's costs, and the borrower will then have a shortfall debt. Once the lender has taken possession of a property, they have a duty to act in good faith when exercising their power of sale. The Financial Ombudsman Service, or FOS, has a useful guideline to mortgagee sales. It outlines FOS's approach in determining disputes. I should add, this published approach is available online on FOS's website if you wish to read it in full. FOS's general rule is that a financial services provider in possession of a borrower's property must take reasonable care to sell the property for either its market value or, if no market value, the best possible price. I will now go through the 6 steps covered in FOS's approach. Just to note, I will use the term lender instead of financial services provider or FSP because it's more straightforward, but FOS refers to credit providers such as banks and other lenders as financial services provider usually. So the first step is what is taking reasonable care. FOS views that the lender can rely on expertise from a marketing agent, valuer or property consultant, but the lender must supervise and make important decisions themselves. They can't just outsource it. The downside for our clients as borrowers is that the lender does not need to consult a borrower about their decisions regarding the sale of the property or keep the borrower informed about the progress. And this can be very stressful for people. However, the lender must promptly tell the borrower once the sale has completed about how they will use the sale proceeds. The next step is valuing the property. What is required when the lender is valuing the property? The lender should get at least one sworn valuation from an independent registered valuer that gives an expert opinion about the property's market value. If the property market is slow at the time of sale, the lender does not need to wait until the market improves before it sells the property, and this is a concern for our clients in WA as the market has dropped significantly. In relation to marketing the property, FOS views that a lender should obtain at least one marketing proposal from a reputable property agent. FOS sets out specific examples regarding what advertising is also appropriate. What is required depends on the property in question, but at least 4 weeks advertising on a commercial real estate website is considered appropriate. For regional and rural properties, FOS considers that local newspaper advertising might be useful as well. Can the lender advertise the property as a mortgagee sale? Yes, they can, but it depends. Generally, only if this is going to increase the interest to the point of allowing the property to get market value. Otherwise, it's not a good idea. The fourth step that FOS would look at is maintaining or improving the property. and the lender generally does not need to spend money to improve the property before sale. The lender also does not need to find new tenants or let existing tenants stay before the sale. And this can be difficult for our clients where the property was an investment property and they're relying on the rental income to reduce the loan. However, lenders may need to pay for common maintenance issues such as repairing broken windows or locks to secure the property, cleaning, gardening and repairing pool fencing. Finally, with insurance, usually the lender will insure the property when it takes possession of it. Now for selling the property. FOS considers an auction to be the most appropriate option for selling a property unless the lender's experts have recommended another approach. In Western Australia, auctions are much less common than in the eastern states, so often a private sale may be appropriate here. If the lender's experts recommend a private sale, the lender must be able to show that it brought the property to the attention of potential purchasers, thus creating competition and achieving market value. The lender will need to set a reserve price for an auction, if it is an auction. In order to set the reserve, it should consider all the available information, such as valuations, marketing reports, and any previous offers on the house. Finally, the last step is proceeds of sale. And that's how the lender can use the proceeds of the sale. The lender must explain to the borrower how it has used the sale proceeds, and this must be done after the completion of the sale, and if there is any shortfall debt before any collection activity starts. The lender can use the proceeds to reduce or pay out the debt the borrower owes to it and any other creditor with a mortgage over the property, and pay reasonable costs incurred in taking possession of, maintaining and selling the property. Usual costs that can be charged are security, insurance and maintenance fees, advertising and sale costs, including the property agent fee, and reasonable legal costs. If there is a surplus following the sale, any surplus should be returned to the borrower. However, if the borrower has loans from the lender for more than one property, then the lender may use any surplus money from the sale to reduce the balance on the other loans. Now we will be talking about shortfall debts and lender's mortgage insurance. We've already discussed what a shortfall debt is. One issue is where there is lender's mortgage insurance in place. Banks and other lenders will sometimes use lender's mortgage insurance to protect themselves in the event that there is a shortfall debt and the borrower cannot pay it off. Essentially, the lender's mortgage insurance allows the lender to pass on the risk of a shortfall debt to the insurer. Often high-risk borrowers, such as those with smaller deposits when taking out a home loan, are required to pay for lender's mortgage insurance throughout the course of their home loan. If the lender does have lender's mortgage insurance in place, then a shortfall debt will need to be paid by the borrower to the insurer and not the lender. However, borrowers can still apply to the lender for hardship, and this is really important for clients in hardship. Lenders may be instructed by their insurer to refuse such requests for hardship. However, in these circumstances, a lender's hardship policy should continue to be applied regardless of the policies or directions of the insurer. Negotiating repayments. If a client incurs a shortfall debt and is having difficulties paying it off, they still have the option of applying for hardship or negotiating with the lender to come up with a repayment plan. And these are the same options as when the client defaults on a repayment early in the progress of their home loan. FOS's view in these situations is that the lender must give genuine consideration to a customer experiencing financial difficulty. A lender should not merely follow the direction of its insurer. If a lender does not form its own view on the customer's ability to repay the shortfall debt under a repayment arrangement, it may be unable to demonstrate that it has met its obligation to genuinely consider a hardship variation.
Thanks, Georgina. Okay, so now I'm just going to talk through a case example of what Georgina's just been talking about with the lender's mortgage insurance. So back in 2015, I acted for Nosiku, who owned a property which was mortgaged to Perth Bank. Nosiku was in arrears on her loan with Perth Bank, and she'd been served with a writ for repossession. Nosiku came to Australia as a refugee from Ethiopia. English was her second language. She found it difficult to understand the writ from Perth Bank, and so we opened a file for her to assist to negotiate a resolution with Perth Bank through the Ombudsman. Perth Bank agreed to allow Nosiku a certain period of time to sell her home. Perth Bank sent through a draft resolution agreement which said that Nosiku would sell her home and the sale proceeds would be applied to the loan account. The settlement agreement also said that Nosiku acknowledged that any shortfall debt remained owed and payable by her. From our calculations, we considered that there could be a shortfall debt of a few $1,000s. So we went back to Perth Bank and requested that they amend the settlement agreement to allow Nosiku time to enter into a payment arrangement for any shortfall amount. Perth Bank initially refused and said that the account had lender's mortgage insurance. As such, they would make a claim on their insurance and then it would be up to Nosiku to negotiate with the insurer. At this point, the Ombudsman stepped in and said that they expected that Perth Bank would attempt to reach an agreement with Nosiku before making any claim on their lender's mortgage insurance. Perth Bank said that they only had a limited time within which to make a claim, and that it was a requirement of the loan contract that the claim be made. They said the process that they usually followed was that they would make a claim with the insurer, and at the same time as doing that, they would also send out a statement of financial position on the insurer's headed statement to the client, and the client would complete this. Once they've received it back, they would then forward it on to the insurer, and the insurer would consider the client's position. The Ombudsman again said that Perth Bank must consider Nosiku's request to pay any shortfall debt. At that point, Perth Bank agreed that if there was a shortfall, they would still send the insurer's statement of financial position to Nosiku, but when they received it back, they would consider whether Nosiku could come up with a suitable repayment plan, and they wouldn't make a claim with their insurer until they had done that. So the settlement agreement was amended to say that if there was a shortfall, Perth Bank would consider a repayment arrangement by the client, and if they considered that the proposal wasn't suitable, they would then make a claim on their insurance.
Okay, now we'll be discussing early release of superannuation. Our office receives many requests for advice on applying for an early release of superannuation to help pay off a loan. At CCLS, we do not provide advice on superannuation, and when we receive such an inquiry, our usual practice is to refer the client to either the Department of Human Services or to our financial counsellor. However, we feel that clients should be made aware of the potential pitfalls in seeking early release of superannuation because it's so important. And going back to Rachael, these are some of the issues that we advised her of. First, early release of super involves a long process including filling out multiple forms and supplying documents. A client may need to wait months, and there's no guarantee that they will be granted an early release. While waiting for the super to get released, a client's debts and interest can accrue and make their financial situation much worse. A second issue is the early release of super will not necessarily solve a client's financial problems. Unless the early release amount pays off the entire arrears of a debt, it may provide only a short-term solution and a client may still end up losing their home. Also, a lender must provide their consent to the early release of super. Lenders will not provide their consent if the borrower is going to default on the next repayment. Lenders usually require a borrower to make a certain number of regular repayments before they will provide the letter to the super fund. A third issue is that super is an asset that is protected even in bankruptcy and from creditors. It's an asset that will be lost upon early release. Finally, it's important to consider the impact on tax and insurance. While superannuation attracts a lower tax rate, as you probably know, funds that are released prior to retirement are taxed at a higher rate. And in relation to insurance, if your client is left without any super, they risk losing the associated insurance benefits that come under super, such as income and disability protection insurance. This is particularly important if the reason for a client's financial difficulty is due to the loss of their mining job. If you are assisting a client with an early release of super application, or they are considering releasing part or all of their super, please ensure that they are both fully aware of the potential risks, both long and short term, of this.
Okay, so the final case scenario I want to talk about is Wendy. Just by a bit of background, we've been assisting a lot of clients at the moment who've had dealings with for-profit debt negotiation companies. As early as 2014, we were contacted by clients regarding one particular for-profit debt advice business, and the business consisted of two related entities. One business looked like a law firm and was called Smiths & Associates. The other business looked like a real estate agent and was called the Real Estate Team. The businesses seemed to be referring the clients to each other. From our investigations, it seemed that Smith and Associates was contacting clients who had had writs for repossession issued against them out of the Supreme Court of WA. And Smith and Associates was advising them that they could help the clients keep their homes. In one case, the client was contacted by Smith and Associates before they had even been served with the writ. In two of these cases, Smith and Associates had told the clients they could assist them with the early release of their superannuation. In Wendy's case, she advised us that she was in arrears of about $18,000 on her home loan, and she had engaged Smith and Associates to apply for early release of her superannuation, and that was supposed to pay off the arrears. At the time she'd engaged them, she had been served with a writ for repossession of her property. She'd been paying Smith and Associates $275 per fortnight for 3 months. During this time, a default judgment was entered against her, but Wendy hadn't understood the significance of this. She understood that Smith and Associates were busy applying for the early release of her super, and she thought it was all in progress. However, at the time she called us, she'd received a letter from the sheriff which said they were going to repossess her home 2 business days from the day she called us. Wendy told us that she'd called the bank, who told her that they had not received any funds from Wendy's superannuation, and so they were proceeding with the repossession. They'd also not had any contact at all from Smith and Associates. Wendy was frantically trying to contact Smith and Associates, but they were not answering her calls. So unfortunately for Wendy, at the time she contacted us, the only real option that was still available to her was to negotiate for time to vacate the property. The time to negotiate to repay the arrears had passed. But what we did do was lodge regulator complaints with ASIC regarding the conduct of Smith and Associates and the real estate team. And we're also in the process of writing to the Supreme Court, as we believe the clients are being targeted after having proceedings issued against them. Finally, we're also in the process of writing to the Legal Practice Board, as we believe that Smith and Associates is engaging in legal practice when they're not authorised to do so. So if your client informs you that they have come across or utilised such a service, we would be grateful if you could refer these clients on to us, and we can add their details onto our regulator complaints. Okay, so that's the end of our presentation, and so we're quite happy now to answer any questions.
Fantastic. Thank you, guys. So a few questions have come through while you were speaking, so I'll just go through those now. In regards to Nosiku's case study, the question is, what is the disadvantage to Nosiku if Perth Bank claimed on that lender's mortgage insurance?
The disadvantage to her?
If there is one.
Yeah, so, I mean, the point of us trying to wrap up the whole dispute in the one settlement agreement is that so that it would all be dealt with at the same time. So it could be, you know, that I think in this case the insurer was actually with a different ombudsman scheme to the lender. So it could have taken time if she wanted to make a complaint to a different ombudsman scheme. Say, you know, the insurer didn't accept her repayment proposal. So there's just the added time with that. I'm not sure what things like insurance claims go on to your actual credit file as well, whether that would then also be listed, there would be a listing by the insurer on her credit file. So yeah, so there were a couple of reasons really that it was more beneficial for her to get that all resolved at the same time.
Okay. So the next question is, what happens if the shortfall debt has already been paid by the insurer? Does the client still have rights under financial hardship, or is it only while the bank still holds the debt?
Well, with the insurers are members of ombudsman schemes as well, so I think I've sort of touched on that with my answer to Nosiku. So the client does still have the option to negotiate with the insurer, and if that settlement proposal isn't accepted, then yes, they can then make a claim with the Ombudsman scheme.
All right, fantastic, thank you. So, of course, we've got quite a few people that are listening from Queensland. So some of the legislation you touched on was, of course, around the Western Australian Act. I've just got a question here. Is the Form 4 applicable to all states in Australia, or perhaps is there an equivalent version for that? So that's the form notice.
Yeah, I know the form you're saying. So look, I couldn't honestly say whether there's an equivalent in Queensland, but the Form 4 that I mentioned, that is specifically to Western Australia, and it's a Form 4 under the rules of the Supreme Court, and it is based on a notice that is already in existence in New South Wales, under New South Wales' legislation around civil procedure and property repossessions.
Mm-hmm.
Okay. I don't know any other states.
It could be a local equivalent of us, really.
True. Yes, I might pass that on. So, Bill, it looks like that's a no, not in its current form, but perhaps you could check out the Queensland Supreme Court legislation just to see whether there's an equivalent in there. The next question is from Heather. So her question is, are the writs on the public record for anyone to access?
Look, that's a good question. That's something that we've been trying to get to the bottom of because of this issue of having all these clients being contacted by these for-profit debt management and debt negotiation businesses. From our research, we can't see how the details are being found by these businesses, aside from actually physically going down to the Supreme Court and asking to access copies of documents. It's really unclear how the contact details are getting passed on to these businesses, which is why we are going to be writing to the Supreme Court about it. I know that writs do get passed on to credit files. So once someone has a writ or a claim here in WA, I'm not sure if it's the same across the country. Once they have those proceedings issued against them, writs and claims are listed as court proceedings on credit files. So whether it's from a business that is accessing people's credit files, we're not sure, and that's why we've got this complaint going on.
So following on from that, we've just had a comment that's come through. It says they exist on court listings, perhaps. So a lot of property flippers sell a database of such listings so they can make cutthroat offers to people facing repossession. Is that your experience as well?
So could you say that again? So there's a property...
So apparently, there's a court on the court listings, and perhaps they could sell an actual database of those listings. So,
yeah, look, I mean, I know there's obviously the court listings, but that would be to actually list a matter in court. So what we found is that people have actually been contacted by these businesses before there's even been a court listing. You know, at the point that the first writ has been actually filed and there hasn't actually been a court date listed yet. So yeah, that is quite correct. There is obviously daily court lists that go up on our Supreme Court website. But yeah, in our case, we're finding that people are being contacted before there's even been a court date.
Yeah, so just a couple more comments on that issue. So Siobhan has just said, I know that lenders can list with a court 12 months before they issue a writ. Is that correct?
I don't... okay, so once a writ has been issued, the lender or whoever it is that issues the writ has got 12 months to actually serve the writ on the borrower or the defendant. Otherwise, the writ does go stale. So perhaps that's what Siobhan's meaning there.
Perhaps. Yes, I think she attended a seminar where the presenters were commenting on the database for sale. So rather than how they got that data, but they did mention that they could access court records. So that's really interesting.
Okay, yeah, we'll definitely try and find some more information out about that property database.
So I've got quite a few questions here, so hopefully you're able to help. So so what happens if the repossessed property isn't sold? So, for example, if actually no one will buy that property, what happens then?
So until the property is actually sold, I mean, the debt just continues to accrue. The interest and any fees and charges, they just continue to accrue on that. So I suppose if the property isn't sold...
In one thing, it would change what would the perceived market value of that property would be, and then I would presume a lender would be entitled to lower the price of that property because the market value would have changed, and then attempt to sell it at a later stage. But yeah, as Gemma said, the loan is continuing and the debts are still accruing and the costs are still client. So it's a tricky situation, but I think it would give the lender under the FOS guidelines, for example, to Mortgagee Sales, probably the right to say, well, we can drop the price, the market value has changed.
Very true. That would be quite a horrendous situation, I can imagine, and certainly something that might come up where these properties have dropped in value quite a lot. So I've got a couple more here. The for-profit debt management people also contact clients in South Australia when banks commence repossession proceedings. We don't know how that happens either. So that's more of a comment there. It's based on South Australia.
Okay.
So does the lender's mortgage insurer have to offer hardship to borrowers once the bank has made a claim to them? What are their rights? Can the insurer sue them for the debt again?
Yeah, so it is a debt owed to the insurer. So it's the borrower's got the same rights as they do with the lender in terms of negotiating a repayment plan with them. And yeah, quite right, if they don't repay that debt to the insurer, then they can risk having proceedings and a judgment against them for that amount.
I think in some cases the insurer may waive that amount, but I think that's fairly rare, to be honest.
Yeah, we have heard of situations here in WA where the clients have just got no way at all of repaying the shortfall debt, and so the debts have been waived.
Okay, thank you. So if this question here, so when a writ is issued, is it served by the sheriff or via mail? So I think this is an issue that's common across the country at the moment, but the comment here is that the mail in WA is notoriously slow, so that would reduce the client's time to respond. So is it in person or?
It is, yes. So a writ from the Supreme Court must be served in person, and it is 10 days from the date of service of the writ that the client has to enter the appearance. If they do live outside of the Perth metro area, then they have 21 days then to respond to the writ. And then in addition to that, they've got that extra 11 days before the lender can apply for default judgment. It is served either by the court or you can engage the lender can engage their own process server to do that. If they think that the borrower or the defendant is being evasive, then they can apply to the court for substituted service. And so that can then be something like leaving it in a mailbox or tacking it to a door, or something like that, really.
Okay, that's good to know. At least they are requiring that personal service there, at least in most instances. This question here is around whether you're seeing an increase of voluntary bankruptcies due to home repossessions.
Look, that's not something we deal with here, bankruptcies. That's more our Financial Counselling Association in WA here deals with the bankruptcy side of things. So we tend to refer clients for bankruptcy advice onto financial counsellors.
Yeah, but we do receive a number of calls to our telephone advice line from people wanting advice on bankruptcy, particularly when they are facing large shortfall debts due to having an investment loan for a property that's dropped in value. And then we do the referral. But yeah, we absolutely do get a number of calls in relation to that.
Very good. Okay, thank you for that. So it looks like we're almost at the end of the questions. If you do have any other questions out there, please send them through. So I've got one here asking how or why the CBA, so Commonwealth Bank, can offer a percentage of a waiver on shortfall and other banks don't. Do you understand that question? Is that something that you're able to answer?
Not really. I think whether a bank or not agrees to waive a shortfall debt, it's up to the bank. It's going to be a commercial decision by them whether they believe that it is worth chasing that shortfall debt, or whether it's just a better business decision for them to just cut their losses. They would obviously have shareholders to account to, so they couldn't, just wipe off all debts. So it would just be, commercial decisions by each lender.
Okay, not a worry. So I think that's everyone answered there. Bronwyn, you've got your hand up. Do you have a question? I'm just going to unmute you, just in case you've got something that you'd like to ask via the microphone. Oh, no. Okay, good. Looks like that question's been answered. So it looks like we're finishing on time today, which is fantastic. Thank you so much, Gemma and Georgina from Consumer Credit Legal Service WA. I think that was a really informative discussion, and certainly having the case studies and sort of working through how you would approach each of those would hopefully have been very helpful for everyone. I think for some of us in Queensland, we might have a little bit of extra research to do just to understand how the processes operate here. But overall, fantastic presentation. Thank you so much, and lots of thank yous coming through from the crowd as well. So we'll see you at the next webinar. Thanks, everyone.
Thank you.
Thanks.